Judgment in the matter of Tindall and another against the Chief Constable of Thames Valley Police.
Lord Burrows will explain this judgment.
The law on the tort, that is, the civil wrong of negligence, draws a fundamental distinction between liability for acts and omissions, or put another way, between making matters worse and failing to confer a benefit. In general, there is no duty of care and hence no liability in negligence in respect of failing to confer a benefit, which includes failing to protect a person from injury, as opposed to making matters worse. The issues in this tragic case raise in an acute form where the boundary lies between making matters worse and failing to protect a person from injury. At approximately 4:30 a.m. on the 4th of March 2014, Martin Kendall lost control of his car on an area of black ice while travelling on the A413 in the direction of High Wycombe. He skidded off the road and rolled into a ditch. He phoned the emergency services and the police came to the scene, as did an ambulance. Mr. Kendall was taken to hospital. The police removed the debris of the accident from the road and then left, having removed the police slow sign that they had put up. They did not do anything about the black ice. Some 20 or so minutes after the police left, Carl Bird was driving in the other direction on the A413. He lost control of his car on the same area of black ice and crossed into the path of a car driven by Malcolm Tindall, which was travelling in the opposite direction. There was a head-on collision in which both Mr. Tindall and Mr. Bird were killed. The widow of Mr. Tindall, Valerie Tindall, has brought a claim against the police, that is against the Chief Constable of Thames Valley Police, alleging that the police are liable in the tort of negligence for her husband's death. The police have applied to have her claim struck out as disclosing no valid claim in law, or alternatively for summary judgment on the ground that her claim has no real prospect of success. The police failed in those applications before the first instance judge, but succeeded in the Court of Appeal. Mrs. Tindall now appeals to the Supreme Court. The Supreme Court unanimously dismisses her appeal. The judgment is given by myself and Lord Legate, with whom Lord Hodge, Lord Briggs and Lady Simler agree. The judgment looks first at whether there could be liability in the tort of negligence on the basis that the police made matters worse. Having looked at a number of leading cases, the conclusion is that there was no such possible liability. The primary contention of the claimant was that the police were liable for having made matters worse because, on the facts, Mr. Kendall, after his accident, had been warning other drivers of the danger and would have continued to do so had the police not arrived. In an important development, the Supreme Court accepts for the first time that there can be liability in the tort of negligence under what has been labelled the interference principle. According to this, there can be liability in the tort of negligence where a person intervenes, provided that that person knows or ought reasonably to have known that that intervention might have the effect of stopping another person's warning or rescue attempts. But on the agreed or alleged facts of this case, the interference principle could not be made out. This was because the police did not know, nor could reasonably have known, that Mr. Kendall had been warning other drivers of the black ice danger and would have continued to do so had the police not arrived. Put another way, the police could not reasonably have foreseen that their arrival would interfere with Mr. Kendall's warnings to other drivers. As far as the police were concerned, he was a victim and was not seeking to protect others. The judgment then moves on from the allegations that the police made matters worse to the allegations that they had failed to benefit other drivers by failing to protect them from the black ice danger. In other words, the judgment moves on from liability for acts to liability for omissions. The judgment asks whether there is any possible liability in the tort of negligence under any of the relevant exceptions to the general rule of there being no liability for failure to protect a person from injury. The exceptions urged upon the court by the claimant were assumption of responsibility, control, and status. But none of these exceptions could be made out in this case. There was no assumption of responsibility by the police to other drivers to protect them from the black ice danger. The police did not have control of the danger in the sense required by law, and no duty of care could arise simply on the basis of the status of the police as professional emergency responders. Mrs. Tindall's appeal is therefore dismissed.